Good morning, Mr. Green. Are you chewing gum? Please spit it out. Is it, hey, guys, is there a trash can over there? She's not smacking.
Okay, let's hit pause. Mr. Green is being charged with unlawful carrying of a weapon, and yes, it's just as serious as it sounds. In Texas, that charge can mean up to a year in jail and a $4,000 fine. But did you notice the judge's demeanor? .com, yet clipped. Judges don't recite rights for fun. This is probable cause territory. Now, here's the real question. Does the scent of weed and a loaded AR-style pistol add up to a legal storm? Or is it just smoke without fire?
Mr. Green, you were charged with unlawful carrying of a weapon. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 4th, 2025, the officer observed the defendant's vehicle traveling on the 8600 block of Colon Boulevard, and the officer began to approach the defendant's vehicle and observed a strong odor of marijuana emitting from that specific vehicle. The officer observed the defendant to make a westbound maneuver onto Belfort Street, and the defendant failed to use a right signal to make a turn onto another street. The traffic stop was then initiated. The officer made contact with the defendant and observed the strong odor of marijuana from the vehicle, and the officer asked the defendant to step out of the vehicle, and the defendant was then detained. The officer asked the defendant if he had recently hotboxed the vehicle, and the defendant stated he had earlier in the day. The defendant stated he had marijuana in a backpack lying on the passenger seat, and the defendant stated he had a rifle and pistol magazine. The officer observed a semi-automatic AR pistol lying on the passenger seat adjacent to the backpack with marijuana inside. The backpack had a bunch of Ziploc baggies containing marijuana, and the weight of the marijuana was 13.05 grams.
Do you have a valid Texas driver license, please?
I'll run it, Your Honor.
Mr. Green, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to be in possession of weapons. Do you understand?
It's eligible, Your Honor.
Unless you have a valid Texas driver license and liability insurance, you're not allowed to drive. Do you understand?
Sir.
Do you have the ability to hire a lawyer, sir? How old are you?
23.
Okay, I'll have you fill out an application to see whether you qualify, and then if you do, then we'll provide your lawyer today. Do not pick up any new cases. Don't violate the law. If I find that you do, I'm going to put you in jail. You understand me? All right, come on.
Right, Judge.
You were here on Mr. Wilson?
This is his first setting. He has a motion to adjudicate. He picked up a new impeding breath upstairs.
Oof.
We're set for the 23rd on that day. We are contesting that vigorously.
He still has other technical violations with us as well.
I don't know if it is significant, but maybe not as significant as the new case.
Sure.
Because I wouldn't want to be on probation.
You know, I'll give you a bit of time, Mr. Monks, but I mean, if it's going to take 2 years,
No, we're not talking about that. We should have some, when did you say we'll come about on the 23rd?
new third.
I was at, if we'll give you, just shortly after that, we'll be able to give you a flavor for what they're thinking.
Okay.
And then we'll go from there.
Done.
All right, I'll pleasure.
You want the same day?
Would you like to come back on both cases on the same day? That means you don't have to come down here 2 days in a row.
Yeah, I think that's
You
better.
want to do the same day?
Yes, sir.
Okay, you got
Thank
it.
you.
All right.
Thank you. You have a great day.
You too.
Have a good weekend.
Judge, are there any bond conditions?
Just the weapons. I mean, I'm sure that the felony court did conditions, you know, so, I mean, we're good.
Okay, thank you.
Yeah, I'm sure the felony court did it.
You want to sit down?
Judge, was the state gonna file conditions for Wilson?
No, just, you speak English, sir, right?
Yeah, if I need help, I can
Would you like me to provide you a translator? What do you speak?
Pashto.
Pashto. How well do you speak English?
Go ahead and sign.
How well do you speak English?
Good. I graduated from high school here.
Okay. Mr. Hashimi, you were charged with driving while intoxicated. You are facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. If you do not understand something, let me know. We'll go slow for you, okay?
If I not hired the attorney, then what?
We will get to the attorney later. We're doing probable cause now. Do you understand?
Yes,
We're going to see if there's enough evidence to go forward with your case. You have the right to remain silent. Anything you say can or will be used against you. You understand?
yes.
If you cannot afford a lawyer will be given to you.
I did it. I just.
Stop. Don't say anything. Just, please,
Yes, Judge. On January 3rd, 2025,
go slow.
at approximately 10 p.m., the officer observed the defendant's vehicle run a red light after the officer was sitting at a cross section with a green light. A traffic stop was then initiated, and the officer made contact with the defendant, who was the driver and sole occupant of the vehicle. The officer observed watery eyes, thick-tongued, slurred speech, confusion, and disorientation. The officer asked the defendant for his driver's license, and he began searching for his wallet, and the defendant then handed the officer his license. The defendant then began making furtive movements, and the officer asked the defendant to exit the vehicle. The officer observed the defendant to stagger and sway on his feet, and the officer could smell an odor of marijuana coming from the vehicle. The defendant admitted to smoking a cigar of marijuana with a friend, and standard field sobriety tests were conducted. The defendant could not follow instructions for the HGN, and the walk and turn found 7 out of 8 clues, and the one leg stand found 3 out of 4 clues. The defendant was read the DIC and consented to breath. The results were both .000, and a blood search warrant was signed and executed.
What was the stop for?
For running a red light, Your Honor.
Okay. Mr. Hashimi, I'm going to find there's enough probable cause to go forward with the case. Would you like me to provide you a lawyer today?
Now,
Hold up, we've got a twist. Mr. Hashmi admits to smoking marijuana and fails the field sobriety tests, but his breathalyzer came back 0.00. That's right, 0 alcohol. So why the blood warrant? Because marijuana impairment doesn't show up on a breath test, and in court, officers need more than just a gut feeling. This is where science meets the Constitution. Question for you, are these tests truly fair, or just legal checkboxes being ticked? Let's talk about it.
I need you to fill out an application for me. I will take a look at it. If you qualify, we will provide you a lawyer today, okay?
Thank you.
Please, wait, hold on. Mr. Hashimi, you are not to consume alcohol or illegal drugs. I will test you. If you test positive for alcohol or illegal drugs like marijuana, I'm going to put you in jail and revoke your bond. Do you understand?
Yes, sir.
Do you see that he has a,
He's eligible, Your Honor.
okay, please.
Next, Judge, counsel is approaching on page 7. Jack, come on up.
Oh, and then I also have Arthur Sims here for, good morning, counsel.
Good morning.
Come on up.
No, Mr. Jack.
Jackson.
Page 7.
Oh, it's Jack. Mr. Jack? Sir, you were charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 4th, 2024, at 9:02 p.m., the officer arrived on scene to a traffic stop. And upon arrival, the officer met with another officer who stated he had called him for backup after initiating the traffic stop for the vehicle reaching speeds of up to 108 miles per hour. The officer observed a strong odor of an alcoholic beverage, slurred speech, watery eyes, and unsteadiness on his feet. The defendant was then detained, and the defendant admitted to having a few drinks at a party. The defendant refused further questioning, and standard field sobriety tests were conducted. HGN 4 out of 6, walk and turn 7 out of 8, one leg stand 3 out of 4. The DIC was read, and the defendant refused to provide a sample. A blood warrant was signed and executed.
You say what had the odor of alcohol, slurred speech, bloodshot eyes? I didn't hear you say any of that.
Yes, he had odor of alcoholic beverage, slurred speech, watery eyes, and unsteadiness.
Got it.
Mhm.
Okay. Mr. Jack, I want to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol or illegal drugs. I'm going to randomly test you. If I find that you're using, it's not going to go well for you. If I find that you're driving like this, in this manner again, I will take your privilege to drive away from you. Do you understand?
Yes.
Do you see that he has a valid license?
I'm running it, Your Honor. It's eligible, Your Honor.
All right. You have a lawyer. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with them. They come back to me, tell me they can't get a hold of you because you're playing games. I will issue a warrant for your arrest. You understand? Don't pick up any new cases. Don't use, stay in contact, and all will be fine. All right. I'll have you sign a receipt with Victoria. We'll have you get with Fleischer for your bond conditions, and then you're free to go. Thanks, guys.
All right, Judge Sims is approaching.
Mr. Sims,
Morning, Judge. How
how are you?
doing well, Judge.
Go ahead and have a seat in the jury box. Right that way.
Good morning, Ms. Plum. Good morning. I wanted to let you know that your lawyer is here with you. He's on Zoom so that you can see that you're not alone. Ma'am, you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Yes, Judge.
Thanks.
On January 3rd, 2025, the officer was dispatched to a shoplifting at Target in Harris County, Texas. The defendant had been caught by the complainant, the loss prevention employee, and the defendant was observed pushing a shopping cart with multiple items towards the front entry without paying for the items. The defendant had passed points of sale before the complainant stopped the defendant. The total was $332.49.
All right, ma'am, I'm going to find that there's probable cause to go forward with the case. I'm ordering you not to go back to any Target. If I find that you go back or you pick up a new case, I'm going to revoke your bond and put you in jail. Do you understand, ma'am? You have a lawyer. Because you have one, I will waive your appearance, but it is your responsibility to stay in touch with Mr. Sims, and he will tell you when you have to come back to court. If Mr. Sims is unable to get a hold of you because you're playing games, you're not responding to phone calls, text messages, then likewise, I'll revoke your bond. We'll have you sign a reset. I'll have you take a seat in the jury box while we get your bond conditions. We'll have you sign it, and then you'll be free to go, ma'am. All right?
Judge, how's March 11th through the 13th?
Did you hear that?
Yeah,
Arthur?
Judge, if we can do the following week, my kids are on spring break that week.
18th through the 20th?
If we can do that Tuesday, that'd be great.
18 it is.
It's yours.
Judge, good seeing you.
You too, man. Take care.
Yes, sir. You too.
Good morning, Ms. Pace. Ma'am, you were charged with driving on a suspended license. You were facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Yes, Judge. On January 2nd, 2025, the officer observed the defendant's vehicle at the 900 block of Burke Road. He ran the license plate and it had a return of an expired registration as of November 2024. A traffic stop was conducted. The defendant was not able to provide a Texas driver's license, so instead the defendant provided a name and date of birth. The defendant stated she did not have financial responsibility on the vehicle, and the defendant was shown to have a suspended driver's license not eligible with multiple Class C warrants.
Okay. Ma'am, I'm going to find that there's probable cause to go forward with the case.
Can I say something?
Please don't. You have the right to remain silent. Exercise that right. Do you have the ability to hire a lawyer?
Yes, I do.
You don't want a court-appointed lawyer? Okay, so we'll give you time to go hire a lawyer. I am making it a condition of your bond that you're not to drive unless you have a valid Texas driver license and liability insurance. And I'm going to have you sign a promise with me today. Doesn't matter what's going on in your life. If you want to drive, go get a license, get liability insurance. If you can show me that, I'll take this restriction off happily. Okay? Bless you. Did you sneeze?
No.
Just sneeze. Okay, man. So I'll have you sign this reset. I'll have you get with Victoria for a reset, and then we'll get you out of here, man. Okay? Thank you.
All right, Judge, next is page 11. Reyes, come on up.
Good morning, Mr. Reyes. Sir, you were charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 2nd, 2025, the officer was riding with HPD Traffic Crimes Task Force, and a group of vehicles was meeting at 430 West Parker Road in Harris County, Texas. The officer observed the defendant, who was 18, brandish a firearm while walking around his vehicle, and the defendant exited from the motor vehicle on the driver's side, walked around the motor vehicle while brandishing the handgun, and then sat in the front passenger side seat. A traffic stop was initiated and the officer made contact with the defendant, the passenger of the vehicle, and the defendant admitted to carrying around a handgun, which was found under the passenger seat in the motor vehicle where the defendant was sitting.
Mr. Reyes, I'm going to find that there's probable cause to go forward with the case. What are you doing with yourself these days? Are you in school? You graduated from high school? Okay. I'm ordering you as a condition of your bond not to be in possession of weapons. You are not allowed to have a weapon. Do you understand? If I find that you have a weapon, you pick up a new case, I'm going to revoke your bond. I will put you in jail. You understand? Tell me, you want a lawyer?
I'm hiring.
You don't want a court-appointed one? You do one? Okay. I just fill out an application. Let me see if I have an application on file. I need you to fill out an application for me. Let me take a look at it, and then I'll appoint you one here in a bit. All right? Come on. Do you mind, Ms. Brown, giving him an application?
All right, Judge, next arraignment is page 13.
Can you
Scott,
file?
come on up.
Yes, Judge.
Counsel, do you have an arraignment?
No, approaching for bond violation.
All right, we're doing the.
Bear with me.
arraignment
I think
first.
we're close.
I didn't want
Are you Mr. Scott?
So,
Mr. Scott, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 4th, 2025, in Harris County, Texas, the officer was dispatched to an assault. The officer met with the complainant, who stated that the defendant and her had been in a sexual relationship, and she confronted the defendant about sleeping with another woman. The defendant became angry and followed her to a gas station where he pushed her to the ground with both hands, causing pain.
Okay, Mr. Scott, I'm going to find that there's probable cause to go forward with your case. Do we know, have you spoken to her to find out what she wants? Does she want to have contact with him? Does she not want to have contact with him?
Your Honor, we have not reached out at this time.
Okay.
A full administration order just dropped. Think of it as a restraining order on steroids. No weapons, no threats, and absolutely no crossing the 200-foot boundary. Why so strict? Because this isn't just about a single incident. It's about stopping things before they spiral. Domestic violence cases are where law, safety, and raw human emotion collide. Here's the question. Should first-time offenders get a chance to prove themselves? Or are firm boundaries like this the only real way to keep people safe?
Like this the only way to keep people safe?
well, Judge,
Hold on a second. Just don't say anything at this point. I've got a bunch of DAs here. Whatever you say, they can use against you. I can give you a lawyer today if you want one. You know, you can give your side to the lawyer. The lawyers can talk to the DAs, but I don't want you to say anything to make the case any worse. All right. Because I don't know what she wants, I'm ordering you not to have any contact with her, not to be in possession of any weapons. I'm also entering what's called a magistrate order for emergency protection that identifies Ms. Walton as a protected individual. You cannot commit family violence or an assault against this person, commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate any threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where she lives or where she works. Do you understand?
Judge, you know the property that she lives, I paid for, approved out on another city, around the definitely homeless, right?
Let's do this. Let me give you a lawyer today. I can have them reach out to find out where she lives, what the address is. I just don't want you to have contact with her. I don't want you to go where she lives or where she works. That's it. Okay? I don't know. Let's do this. Let me give you a lawyer and we'll go from there, okay? Do not leave until you sign our bond conditions, though. Sorry?
Please respect the nominal key of your representative approved in court 1990.
So hang tight with me. We'll help you out. Don't worry, okay? Please. Can you, hey, no contact, no weapons.
For now, counsel, you may approach.
So that was the last one.
For now, it's just.
No Spanish? No.
No.
Wow, okay. Hi,
Aaron Durden.
okay. Come up, Mr. Durden.
Mr. Durden was placed on bond conditions in November, toward the end of November, got an interlock at the end of November. His very first date to go have it recalibrated was 12/29. He was out of town on that date, didn't get back until the next week when it was locked out. I got an email on Monday from the trial officer saying that he was locked out and notified you as well. He went the very next day, got it fixed, but you asked us to come here today to address it. He now understands.
I'm not going to play this game with you. Court orders are court orders. You have to follow them. And when you don't, there's severe consequence. And the consequence is you end up in jail. So I'm going to give you a pass now. But if it continues to happen, it's just not going to go well for you. Do you understand?
Yes, sir.
Okay. All right. That's it.
Is our date that we have for the training still on? Thank you. I'll do that.
You ready? Hi.
He was here for a bond violation because of a lockout, Your Honor. He since remedied that. Apparently his power battery
Do
shuts
you
off.
mind bringing them up?
Unconditional, yeah.
Yeah. Nothing.
Between them and the state, you know.
I'm not going to play this game with you, Mr. Kabir. If this continues to happen, it shows me that you're just don't care about the bond conditions and their severe consequences. Do you understand?
Your Honor, I don't drive this
I'm
vehicle.
I don't want you to, I'm just telling you, I have bond conditions in place and I expect for you to live up to them. And when you don't, there are severe consequences. Do you understand? Okay. You guys didn't want to add anything? Or did you have something to add? No?
No, Your Honor. No, that was it. That was the only reason.
Okay. All right, man.
Thank you.
Good morning, Judge. May I approach?
Yes, ma'am.
I'm here on an arraignment. My client, Battleground, B-A-R.
I'm ready when you are. You might bring them up?
Yes.
Good morning, Mr. Barragan. You were charged with racing on the highway. You were facing up to a year in jail. I'm sorry, up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Yes, Judge. On January 5th, 2025, the officer was part of a street racing and takeover task force and was advised of a group that met at a gas station parking lot in the city limits of Harris County, Texas. The officer was working in a plainclothes capacity and was following the group from one location to another and viewed two vehicles race side by side at Highway 290 and Kickapoo Road, traveling westbound. The officer observed the defendant's vehicle and another vehicle slow down to approximately 50 miles per hour before launching at the same time in a competitive manner, accelerating well over 100 miles per hour in an attempt to outpace one another. The officer maintained visual and was able to detain the defendant, the driver of the silver Nissan observed, but was unable to locate the other vehicle.
How fast are we talking over 100?
Let me see if he specified, if it was just that. The officer only said well over 100. He didn't specify.
Barragan, I'm ordering you as a condition of your bond not to participate in this kind of activity again. If I find that you're racing, if I find that you participate in any kind of street takeovers, anything of this nature, reckless driving, donuts, whatever, I will take your ability to drive away from you. Do you understand? Not only that, it is a condition of your bond, and if I find that you do, I can revoke your bond and put you in jail. Can you file those conditions, please?
Yes, Judge.
You're going to reset your case to give you time to fight this thing. I'm going to have you sign a reset, Victoria. I'm going to have you take a seat in the jury box. We'll get your bond conditions. We'll have you sign it. And then after that, you'll be free to go. You have a lawyer. Because you do, I will waive your appearance, but it is your responsibility to stay in touch with her. If she tells you she can't get a hold of you because you're playing games, you pick up a new case, you've become a danger to my community, I will put you in jail. You understand? Okay, come on. Thank you.